This is what's happening in the United States of America while you waiting for the NBA playoffs to get started. This is what's happening in the United States of America while you spending $500 on fake hair. This is what's happening in the United States of America while you running around looking for another white girl to marry or impregnate. This is what Supreme Court Justice Clarence Thomas did. Now, some of y'all going to say it ain't just black people because you're so damn multiculturally stupid. You're so multiculturally stupid that when somebody brings up black people, you got to fight for everybody who not black. That's how sick we are. When somebody talks about what's happening to black people, you start talking about everybody who's not black. I don't know. Clarence Thomas is the Charles Barkley of the legal system. Judge Clarence Thomas is the Charles Barkley of the legal system. If Charles Barkley was a Supreme Court justice, he would be Clarence Thomas. This is insane. Ineffective assistance claims virtually always require the presentation of evidence that isn't already on the record. According to Justice Sonia Sotomayor's dissent, and an amicus brief by government offices that represent death row inmates in federal proceedings in about 18 states, so-called habeas proceedings come after an appeal and are intended to ensure prisoners were sentenced in compliance with the Constitution. In September of last year, 2021, a Texas man had been on death row since 2003, had his conviction overturned because of new evidence of egregious misconduct by the judge and or attorney. The conflict of interest in Clinton Young's case was discovered only by happenstance, and he came within days of execution in 2017 after his federal habeas petition was denied. Under Clarence Thomas's ruling on Monday, and of course this was last spring of 22, federal courts will be compelled in many instances to simply disregard similar evidence of innocence or inadequate representation if it wasn't presented during trial or appeal. Did y'all hear that? Black people are disproportionately on death row. Black people are disproportionately on death row. Black people are disproportionately on death row. And Supreme Court Justice Clarence Thomas made all these black men and some women on death row, not including all the cases that don't involve death row, but involve spending most of your life in prison. These brothers and sisters cannot fight for a new trial, nor can they fight to present new evidence to reopen an old trial through which they were wrongfully convicted. This is what's happening in the United States of America while you waiting for the NBA playoffs to get started. This is what's happening in the United States of America while you spending $500 on fake hair. This is what's happening in the United States of America while you running around looking for another white girl to marry or impregnate. See? Some of you are of the opinion that those of us who fight for African justice are exaggerators, that we overlook the good that America does for black people. I'm going to need you to explain to me what good does America does to black people when innocent people with evidence, innocent people with evidence that can prove they were not guilty of a crime cannot enter that evidence at a later date to save their life from being taken or from being wasted through a long prison system, a sentence. If the judge did something wrong, they can no longer do anything about it. If the attorneys didn't carry the case right, they can't do nothing about it. No constitutional protection for black people convicted without proper introduction of all evidence. They can no longer get that overturned. This is what Supreme Court Justice Clarence Thomas did. Now, some of y'all going to say it ain't just black people because you're so damn multiculturally stupid. You're so multiculturally stupid that when somebody brings up black people, you got to fight for everybody who not black. That's how sick we are. When somebody talks about what's happening to black people, you start talking about everybody who's not black. We are disproportionately incarcerated. We are disproportionately arrested, and we are disproportionately sentenced to longer prison term. That's not coming from me. That's coming from the United States Sentencing Commission. The U.S. government says we're over arrested, overly convicted, and overly sentenced. So who do you think Judge Clarence Thomas was targeting when he decided to overturn our brothers and sisters' rights to reopen cases and present new evidence? Who do you think he was referring to? Who do you think he was referring to? Let's continue. Clarence Thomas's opinion ignores the evidence of innocence in Jones's case, numerous documented wrongful convictions around the country, including death penalty cases. He didn't even make an exception for death penalty cases. And the research suggesting there's probably even more innocent people in jail than we might think. Of course there are. How do we know there's more innocent black people in jail? How do we know this? We know this because most black people in jail can't afford decent legal representation, so most of our cases are plea bargained to begin with through the public pretender. Most of our cases are plea bargained to begin with through the public pretender. Plea bargained. We take a deal because we can't prove we're innocent, and according to Clarence Thomas, once you can prove you're innocent with evidence, you cannot introduce it. Lord have mercy. The National Registry of Exonerations lists more than 815 exonerations since 1989 involving inadequate legal defense. I'm going to say that again so y'all can understand the magnanimity of this problem. The National Registry of Exonerations says more than 815 people had their conviction overturned due to inadequate legal defense. In other words, the judge shammed them. The judge scammed them. The public pretender sold them out. 815 people had their cases overturned since 1989 because of inadequate legal defense, including more than 44 who were sentenced to death. Including more than 44 who were sentenced to death. I think that was Barack Obama's president's number, wasn't it? Wasn't he 44? Interesting analogy there. The decision also overlooks the crisis of inadequate representation in public defense and that successful habeas petitions are already exceedingly rare. Federal courts in Pennsylvania, Florida, and South Carolina granted habeas relief in just 38 petitions between 2012 and 2021. Only admitted evidence in 19, according to an amicus brief filed by a group of academics. Monday's opinion by Supreme Court Justice Clarence Thomas, we're talking spring of 22, centered on an interpretation of the Anti-Terrorism and Effective Death Penalty Act of 1966, which severely curtailed post-conviction petition. To be sure, post-conviction appeals involve procedures that may be obscure to non-lawyers, and some of the former legal issues in the Ramirez case, like exhaustion or federal state comity, might seem complex. But the conservative majority's legal analysis isn't particularly complicated in any real sense. It amounts to a conclusory determination that the government efficiency achieved by restricting prisoners' ability to challenge convictions is preferable to strengthening judicial integrity by continuing to allow appeals in multiple forms. The core of the majority's reasoning is that a federal order to retry or release a state prisoner overrides the state's sovereign power to enforce societal norms through criminal law and imposes significant costs, including undermining respect for the finality of state court judgment. I got to read that again because that was ridiculous. Listen to this. The core of Judge Thomas's reasoning is that a federal order to retry or release a state prisoner overrides the state's sovereign power to enforce societal norms through criminal law and impose a significant cost. So Clarence Thomas says it costs too much. Lord have mercy. Ancestors, be with me, be with me, be with us. We will not lose, we will win, we will not quit, we will fight. Clarence Thomas said it costs too much money to have your brother's case reopened and new evidence presented. It costs too much money to have your mother's case, your father's case, your nephew, your sister, your auntie, your soror, your frat brother, your next door neighbor, a young black boy tried as an adult, young black girl tried as an adult, falsely convicted. Clarence Thomas says it costs too much money. He says, quote, imposes significant costs. Imposes significant costs, including undermining respect for the finality of state court judgment. In other words, states' rights. Clarence Thomas is invoking the same argument that the Confederacy invoked with regard to slavery. Clarence Thomas is invoking the same argument that slave states invoked with regard to how or why the federal government had no right to force them to an enslavement of African people. They're making the same exact argument, states' rights. So Clarence Thomas says it's the state right. If you were wrongfully convicted, that's not our fault. Handle it with your state. And it costs too much money to reopen your case. Lord have mercy. I hope y'all listening. I hope all you Negropeans are listening. The ruling demonstrates an indifference to wrongful convictions and unwillingness to examine the mistakes of law enforcement and judicial officers. Even the central holding that federal rehearings undermine state power is derived from a 1998 case, Caldering versus Thompson, that resulted in an execution of a man many believe was probably innocent. Stephen Reinhart, former Ninth Circuit Court of Appeals judge who heard the case against Thomas Thompson, said in a 1999 lecture that Thompson was likely innocent, and a former prosecutor who authorized the California law that led to his execution later became a death penalty abolitionist because he believed his work resulted in the death of an innocent person. Underneath the simplistic legal analysis in Monday's case, the justice's ruling is apparently animated by the same concerns raised by mostly Republican politicians in the Clinton White House while pushing to enact the Effective Death Penalty Act. Clinton White House. Clinton White House. The statute was drafted, enacted, and signed in an atmosphere of anger and fear following the heinous Oklahoma City bombing. Brian Stevenson, law professor of New York University School of Law, wrote in a 2002 Law Review article, conservative lawmakers were primarily concerned with swift punishment as retribution and a deterrent, putting people convicted of horrible crimes to death as soon as possible. According to Stevenson, and additional research by Judith Ritter, a Widener University Delaware Law School professor, it didn't matter that the bomber, Timothy McVeigh, was a federal prisoner and that the statute largely impacted state prisoners. The court's approach to habeas petition since the 1990s has similarly been shaped by political variables and unexamined assumptions about prisoners and their lawyers. Much of the current shape of habeas corpus law reflects the Supreme Court's and Congress's belief that state courts are adjudicating constitutional issues in capital cases fairly. In all, the conservatives' ruling elevates process over substantive justice, apparently based on nothing more than the unexamined belief that people who get arrested, tried, and convicted are probably guilty and should be swiftly punished. Unfortunately, most Americans already know the reality is quite different. That was a brother who wrote that, Hassan Canoe. Great article, my brother. He was born in Sierra Leone, grew up in Silver Spring, Maryland, worked in public interest law after graduating from Duke University School of Law, spent 5 years reporting on mostly employment law, lives in D.C. Great job, brother. Hopefully you don't have the snow bunny crisis. Hopefully you don't have the snow bunny crisis. The reason Clarence Thomas did that, save money, respect state sovereignty, And so the Republican Party can look like they're tough on crime. Because after all, white folks care about what? Republicans being tough on black crime. That's all it is. That's all it is. Tough on crime is nothing more than being tough on black people in the name of crime. And Clarence Thomas wants to make sure that his party continues to look like they're being tough on crime, and he don't mind black people being sentenced to death unjustifiably, unfairly, and unnecessarily just to improve the image of his Republican Party. Brothers and sisters, I might got to take the LSAT. I got to build schools all over the diaspora, but I might got to take the LSAT. I won't be able to take a lot of cases because educating our kids is, in my opinion, more important. But I might have to take some cases. I might have to take some cases, brothers and sisters. We talking about criminal justice because we ignore too much the fact that we got brothers and sisters and family and loved ones and Africans, members of our family, our extended African family in jail, suffering. Poor food, poor housing, poor medical care, poor quality of life for crimes they didn't even commit, but they couldn't afford decent, legal, adequate representation. Why don't the black athletes and celebrities create criminal justice funds for black people? How about some criminal justice funds for black people? How about some criminal justice funds so when people go to jail unjustifiably, not when you're guilty of wrongdoing, but you went to jail unjustifiably and your only crime is being poor and not having enough money to pay for an attorney? Our celebrities should be able to create some criminal justice funds. What's up with that? What's up with that? If we're going to have a real conversation about celebrity accountability, let's have a real conversation about celebrity accountability. But I'm going to say this before that. There got to be black community accountability before there can be black celebrity accountability. There has to be black community accountability before there can be black celebrity accountability. There has to be black community accountability before there can be black celebrity accountability, brothers and sisters. This is King Kong Consciousness, the Prince of Pan-Africanism, Dr. Umar Tunde, signing off.